Alison, good afternoon. Thank you very much for your time. Just first up, just to clarify my understanding, I might have got it wrong. Was the regulator part of this court case?
Yes, the regulator was cited as a respondent.
Yes, and what was your position? What is the position you took in court?
The position we took was to abide the decision of the court, so we didn't oppose the application, and the order was made essentially without opposition from Department of Basic Education or ourselves.
Yeah, some of us find that a little bit odd that the department took this matter to court using the POPI Act, and that doesn't oppose it. But we're not even now, as I'm standing here talking to you, I'm not even aware what were their key arguments in the first place. Where were the concerns that the POPI Act was hamstringing the department or preventing them from publishing the matric results as it has been done in this country ahead for many years before the POPI Act came into effect last July?
So I think the court application, AfriForum, were the applicants in the matter. But prior to that, the regulator and the Department of Basic Education had been talking about these results. And the regulator is obviously not an expert in exam results and how they're made public. So the regulator and the Department of Basic Education had a series of discussions about exactly how the information is de-identified. And I think by the time they'd finished our consultations, the regulator was certainly of the view that the information has been de-identified and that the department is not prevented by POPI from releasing the records. I understand there are other arguments about why the records shouldn't be released, but those are really arguments by educators. And we, as the information regulator, only deal with the issues around POPI.
So in your view, from just listening to what you've just said now, the Department of Basic Education should not have really announced that it's being prevented by the POPI Act from publishing matric results, or did they have legitimate concerns? Does the Act stipulate, wherever it does, if it does, that this could be a problem?
Look, it was a decision that took place over a number of weeks with consultations with the Department of Basic Education, in us meeting with them and them explaining to us exactly how the exam results are de-identified, and we had to speak to a number of people in that regard. And of course, the regulator itself then had to formulate a view on whether or not the information is sufficiently de-identified, because de-identification isn't a yes or a no. It's is it reasonably de-identified, and that's always a question of fact. And as I say, the regulator is not an expert in how DBE or the media houses, for that matter, were going to treat the records. But I think we certainly all came to the conclusion that the release, as the Department of Basic Education outlined it, was okay in terms of POPI if there are matriculants who feel that their personal information has been violated, and perhaps the system of de-identifying their record didn't work. They would, of course, be entitled to lay a complaint with the regulator.
Okay, Alison, so just to get another clarity, so at some point in that consultation process that you've just outlined, the DBE came to know that in terms of POPI Act, they could go ahead and publish those results.
I think the introduction of POPI has been a learning curve for everybody, and we're very happy to engage with content experts in order to make sure that POPI is complied with as a new and complex piece of law.
Did this matter have to end up in court? I mean, if that consultation process that involved the DBE and the regulator sort of clarified the areas that might have been grey in terms of the matric exams, did it have to end up in court?
Well, whether something has to end up in court is always an open question. There certainly were tight deadlines, and I think what the regulator is saying is that for next year, and next year will come sooner than one ever thinks it will, it really is important for people to think through what the privacy implications are for how these records get published. And I understand there are also issues from educators about whether or not the records should be published, but that's obviously not a copy issue.
Yeah, I mean, I'm just thinking if I'm AfriForum, somebody took it to court and now the court has ruled in favor of the publication, I might see this somehow as a kind of a victory of sorts. Are the winners or losers in this particular matter? In your view, I'm just asking for your a kind of reflection on it. What do you think?
Well, I think the learners are the winners in the sense that their information is protected, but they do also get the information that they want. And that's, of course, the intention is that there is both access to information and privacy at play. And as always, the best interests of people under 18 is children, and of course, grown-ups as well. I'm not suggesting everybody's under 18, but I think that's really what we have to focus on in this situation.
Okay, Alison Tilley, thank you very much for your time and insights. Member of the Information Regulator of South Africa. They were a respondent in this matter in court. And now, of course, the High Court in Pretoria earlier ruling that the matric results will be, as usual, published on all relevant public media platforms.